Sullivan, one of three elected commissioners of the city of Montgomery, Alabama, testified he was Commissioner of Public Affairs, and the duties are the supervision of the police department, fire department, department of cemetery, and department of scales. He brought this civil libel action against the four individual petitioners who are Negroes and Alabama clergymen, and against petitioner, the New York Times Company, a New York corporation which publishes the New York Times, a daily newspaper. Respondents complained alleged that he had been libeled by statements in a full-page advertisement that was carried in the New York Times on March 29, 1960. Below these names, an underlined reading, "We in the South who are struggling daily for dignity and freedom warmly endorse this appeal," appeared the names of the four individual petitioners. One of Sullivan's witnesses, a former employer, testified that if he did believe the statements, he doubted whether he would want to be associated with anybody who would be a party to such things that are stated in the ad, and that he would not re-employ Sullivan if he believed that he allowed the police department to do things that the papers say he did. But neither this witness nor any of the others testifying actually believed the statements in their supposed reference to Sullivan. The cost of the advertisement was published by The Times upon an order from a New York advertising agency acting for the signatory committee. The agency submitted the advertisement with a letter from A. Philip Randolph, chairman of the committee, certifying that the persons whose names appeared in the advertisement had given their permission. Each of the individual petitioners testified that he had not authorized the use of his name and that he had been unaware of its use until receipt of the respondent's demand for a retraction. The manager of the advertising acceptability, the Times responded to Sullivan that "we are somewhat puzzled as to how you think the statements in any way reflect on you." When asked to explain why there had been a retraction for the governor but not for Sullivan, the secretary of the Times testified, "We did that because we didn't want anything that was published by the Times to be a reflection on the state of Alabama, and the governor was." The conclusion is that the Constitution affords the citizen and the press an absolute privilege for criticism of official conduct and does not leave the public official without defense against substantial opinions or deliberate misstatements. The court announced a constitutional standard which prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves the statement was made with actual malice, with the knowledge that it was false, or with reckless disregard, or whether it was false or not. Elmer Gertz, a public figure and lawyer who represented the Nelson family in a 1960s lawsuit when a family member was murdered. Robert Welch, the managing editor from American Opinion, who made false accusations based on Gert's history. In March 1969, Respondent published the resulting article under the title "Frame Up: Richard Nucio and the Warren Police." Gertz didn't discuss Officer Nucio with anyone during the criminal proceeding. Welch's magazine portrayed him as an architect of the frame-up. According to the article, the police file on petitioner took a big Irish cop to lift. The article stated that the petitioner had been an official of the Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society, which has advocated the violent seizure of our government. It labeled Gertz a Leninist and a communist frontier. The implication that Gertz had a criminal record was false, and he had never been a member of the Marxist League for Industrial Democracy are the Intercollegiate Socialist Society. The manager editor of American Opinion made no effort to verify or substantiate the charges against the petitioner. He included in the article a photograph of Jertz and wrote in the caption, Elmer Jertz of Red Guild harasses Nucio. According to my understanding, Welch felt Jertz had an issue with the cops and used it as a motive to make himself look good. The problem was Jertz gave no proof he had a problem with the law itself and protected the Nelson family. Meanwhile, Welch didn't believe the act and used his authority to call Jertz out on what he believed. By using his power of being a part of the press, he knew Jertz's image would be hurt, therefore showing what kind of man he really was. For these reasons, Jertz argued he was entitled to invoke the privilege enunciated in New York Times Co. v. Sullivan, 376 U.S. 254, 1964. Under this rule, Welch could escape liability unless Jertz could prove the publication was falsehood with actual malice. Jertz claimed the falsehoods published by respondent injured his reputation as a lawyer and a citizen. Before filing an answer, Jertz moved to dismiss the complaint about the failure to state a claim upon which relief could be granted, apparently on the ground that Jertz failed to allege special damages. The editor denied any knowledge of the falsity of the statements concerning Jertz and stated that he had relied on the author's reputation and on his prior experience. He concluded that the First Amendment gives the press privilege to report and comment upon Jertz's actions with full details and no requirement to be spared from the public. This question is hard to answer because Jertz technically did nothing wrong. In his defense, he only did his job as a lawyer to defend the Nelson family, who was only hurting because a younger member of the family was shot and killed by an officer who seems to clearly be hiding behind the law. But to be fair, in the 1960s, times were rough for black folks. While Martin Luther King Jr. was trying to fight for their right, in a way, the best Jertz could have done was to stay clear of the case. But as a lawyer, it goes against what he trained for. Another way of handling this scenario would be to assign another lawyer to the case and act as support for the main lawyer, who was being used as a frontman to represent the Nelson family and get their justice for what the officer has caused them, physically, emotionally, and mentally. Elements of defamation in Connecticut. The false statement can be made willfully, recklessly, or negligently. The statement must have been published or communicated to a third party, must identify the defamed party, but the identification need not be made only by name, must suffer reputational damage as a result of the statement. Whether the claimant actually suffered damage is usually a question for a jury or judge to decide. These cases taught me that defamation can come in many forms, but depending on what approach the writer delivers it, that determines the outcome of how others will view my work. Not only is it enough to prove what I can talk about, but the concern for what can be used against me is another factor that puts my reputation and image on the line. Even though I follow through with my training and do whatever I am told by the books, there are loopholes that can be broken and still create a mess. Staying away from the topics are easy, but then it's what journalism is all about, reporting what needs to be told.